Miwasin, Gisagal, Askini Pawin, Nasikasun, Atsiniwachitse Gotsinia. Hello, my name is Sapphire Carter. I'm from the Rockaways Reservation. I'm from the Chippewa Cree tribe, and I welcome you here, a part of the Native American Law Students Association and the Federalist Society, for our panel on protecting sacred spaces. I would like to introduce our panelists. Professor Michael Steele. Michael Steele grew up in western New York on the Cattaraugus Reservation of the Seneca Nation of Indians. Michael graduated from Brigham Young University with degrees in humanities, BA and Masters of Arts, and a JD from the Georgetown University Law Center. She is the Marion G. Romney Professor of Law and has served as the Associate Dean for Faculty and Curriculum and the Associate Dean for Research and Curriculum at the J. Reuben Clark Law School at Brigham Young University. Professor Steele's scholarship focuses on the sovereign powers of Native American tribes and has been published in the Harvard Law Review, the New York Law Review, and the UCLA Law Review, among others. Prior to joining the Academy, Professor Steele worked as a counselor to the Assistant Secretary for Indian Affairs at the U.S. Department of Interior, as an associate at the D.C. firm specializing in representing tribes, Sonosky, Chambers, Sash, Anderson, and Perry, and for 6 years as a trial attorney at the U.S. Department of Justice's Civil Rights Division, as part of the Housing and Civil Enforcement section. Her work at the Department of Justice was honored with several awards, recognizing her achievements in Fair Housing Act investigations and litigation. Professor Steele teaches federal Indian law, civil rights, and constitutional law. Beth Wright. Beth Margaret Wright rejoined the Native American Rights Fund team as a staff attorney in 2022, having previously served as a Native American Rights Fund summer law clerk. Throughout her education and career, Beth has focused on advancing Indian country's next generation. Her work is inspired by a desire to uplift Indigenous joy, strength, and success. At the Native American Rights Fund, she devotes much of her attention to Indian boarding school healing, history, and policy, but she also tackles issues related to Indian child welfare and Indigenous methods for dispute resolution through the Indigenous peacemaking initiatives. Beth's dedication to the Native American community extends beyond her work at the Native American Rights Fund. She is an avid runner who feels that running is what keeps her closest to her community. She is a repeat Boston Marathon finisher. And then our last panelist, Joe Davis. Joe Davis joined the Beckett Fund in 2017 as legal counsel. His work at Beckett has included appellate litigation in both federal and state courts, including representing religious entities and governments sued because of their openness to religious expression and precedent-setting victories before the 3rd, 5th, 7th, and 11th circuits. Joe has appeared in national media to discuss religious liberty issues, including on Fox News and numerous radio print outlets, and his academic work on topics related to religious liberty has been published at venues including the Yale Law Journal Forum and the Notre Dame Law Review Online. Before joining Beckett, Joe worked as a litigator at Jones Walker LLP in New Orleans, Louisiana, where he worked on a variety of matters from commercial and criminal litigation to bankruptcy. From 2014 to 2015, he clerked for the Honorable E. Grady Jolly of the U.S. Court of Appeals for the Fifth Circuit. Joe graduated summa cum laude from the University of Virginia School of Law in 2014, where he served on the Virginia Law Review and was elected to the Order of the Coif. While in law school, Joe studied religious liberty law with one of the top religious liberty scholars and litigators in the nation. He also worked as a researcher for the law school's Supreme Court Litigation Clinic. Before going to law school, Joe received his BA in economics with a minor in religion, summa cum laude, from Mississippi State University. Joe is married to his high school sweetheart. When he's not helping her corral their 4 young children, he tends to be reading the classics, watching college football, or listening to his vinyl collection. So thank you all for coming. Please join us at the table. Our panel focuses mainly on the recent Ninth Circuit case, Apache Stronghold, which is now up for cert at the Supreme Court. We will have 5 minutes for each panelist just to discuss their thoughts about Native American religious freedom and protecting sacred spaces.
Hi, everybody, and thank you so much for having me here. I'm really excited to be here and talking to you about this super important case on this panel with these very distinguished panelists. So the Beckett Fund, where I work, we're a nonprofit law firm. We do exclusively religious liberty litigation, and we do it for people of all faiths, as we like to say, from A to Z, from Anglicans to Zoroastrians. So we have a lot of experience representing people of all faiths, including at the U.S. Supreme Court, where we've represented an order of Catholic nuns, a Muslim prisoner, an Orthodox Jewish synagogue, and many other clients. So I just wanted to give you kind of a sense of the breadth of our work. But the issue that we're here to talk about today, I think, is actually one of the most important religious liberty issues out there, and also one that doesn't get discussed, I don't think, nearly enough. Like, a lot of times it's the hot button social issues that take up a lot of the airspace in the religious liberty field, and I'm happy to discuss those too, but this issue of Native American sacred sites is extremely important, really of existential importance to many Native American religious traditions. And so what are these controversies, or what are these conflicts? They typically arise because many Native American religious traditions, and I'm sure the rest of the panel will discuss this more as well, but many of them are place-based. Like, there are particular exercises that have to take place at certain sites, and they can't take place anywhere else. But because of our history, many of those sites are now controlled by the federal government. And so what happens when the federal government wants to put the site to some other use that's inconsistent with it being used for Native American religious practices? And that's where these religious freedom cases come in. And the Apache Stronghold case that's up at the Supreme Court right now is really a great example. So what's Apache about? Apache is about a case, it's about a site in Arizona called Oak Flat that is sort of the core site for many Apache and other Native American religious traditions in the area. There are rituals that take place there that cannot take place anywhere else. They view it as a direct corridor to the Creator. It's an extremely important site in their religious exercise. But and its own land that's controlled by the federal government. The problem is, several decades ago, somebody found quite a bit of valuable copper underneath Oak Flat. And what the federal government now wants to do is to transfer Oak Flat to a private mining company that's then going to turn it into a copper mine. And that will swallow Oak Flat in a giant crater, and it will end religious exercise there forever. Nobody disputes that. So the question is, does religious freedom law have anything to say about that, about a religious exercise being permanently extinguished because the place at which it must take place has been entirely destroyed? I think the answer to that ought to be a pretty obvious yes, right? We have not only the First Amendment, but there's a statute called the Religious Freedom Restoration Act. And what RFRA says is that if the federal government puts a substantial burden, that's the language of the statute, on somebody's religious exercise, basically it has to have a really good reason to do so. We shift the burden to the government and we make it come in and prove up its case. Like, why do you have to do this? Is there any other way of doing what you're trying to do? And so that's the statute that the Apaches pointed to in the Apache Stronghold case. And they said, of course this is a burden. Our site is being entirely destroyed. It's not only a burden, it's rendering our exercise there entirely impossible. So prove up your case, government, on strict scrutiny. But the Ninth Circuit reached the counterintuitive result that actually this is no burden at all. The Ninth Circuit determined that there was sort of a land use carve-out from RFRA that appears nowhere in the text of the statute. And so it said that you can do this if you want. You can do it to make a copper mine, or you can do it for any reason at all. There's just no scrutiny that applies under federal religious freedom protections. I think that's a very strange and harmful opinion. It was a fractured Ninth Circuit. It was 6-5, so this case went en banc. And for kind of strange procedural reasons, there were multiple opinions in the case, and as a whole, the court was 6-6, although not at the en banc stage. So a very fractured Ninth Circuit. And so we are representing the Apache Stronghold, repealing that decision to the U.S. Supreme Court. The petition is pending in front of the court, and they've had it in front of them for quite some time. So we could have a decision any day as to whether or not they're going to take the case. And we've been helped in that enterprise by some great scholarship from Micklin, talking about how the burden analysis should work in Native American sacred site cases, and I'm sure she'll discuss that. And also with a great amicus support from Beth and from many others. It's really an ecumenical amicus outpouring of people from all religious faiths asking for the Supreme Court to weigh in on this case. So I think that kind of sets the groundwork there.
Thank you, Joe. I'm really happy to be here, grateful for the invitation. I've wanted to come up to University of Montana Law School for a long time and have admired the work of your professors here. So I got mixed up in all of this because I teach federal Indian law, and we have a couple of cases that we read about how Native religion and culture fares under our legal system and what protections are available. If we can categorize it as religion, and I think we fairly can categorize it, even though that category doesn't sit totally easily, but it is religious exercise, then we have the very Constitution and the Bill of Rights that ought to protect that exercise. And it's not just the freedom to believe something, but the freedom to practice those beliefs or to abstain from certain behaviors. That's the exercise of religion. But the Supreme Court's jurisprudence in this field has been interesting, and there was a case called Bowen versus Roy, where Native American parents did not want their daughter to receive a Social Security number because of their belief that it would negatively affect her spiritual development. I may not be saying that correctly, but that was a Native American setting in which the court said, no, everybody gets a Social Security number. It applies to everyone. We're not singling you out for we're not punishing you or preventing you from believing it, and so you are just subject to that law, and you don't get an exemption because of your religion. And then I may not have this order exactly right, but there is a case that's very important to what the Apache Stronghold case is able to claim, in which the government was proposing to build a logging road that would devastate the sanctity of an area in California for Native practitioners. Their ability to practice there would be very limited and so disrupted. So there's two kinds of claims. One is if you don't have access to the place, and the other is if what the government is doing desecrates or sort of diminishes the sanctity of the place and interferes then with even if you can physically be there, but interferes with the experience. So desecration and access cases. And the Supreme Court said, usually under the First Amendment analysis, the Free Exercise Clause, you have to say, my exercise of religion has been substantially burdened by what the government is trying to do. And then they make that analysis, and as Joe described very clearly, the government then has to say why it has a compelling need to do what it's doing, and it's using a narrow tailoring to do what it's doing. In Ling, the Forest Road case, the court said we don't even have to get to that analysis under the First Amendment because the religion is not substantially burdened, the exercise of the religion, because we're not coercing you not to believe it's sacred, and we're not punishing you for trying to practice your religion. And if you can't satisfy that coercion test, then we don't have to undertake. It doesn't equal a burden that then triggers First Amendment analysis. And then a case called Employment Division versus Smith, which involves the use of peyote. And so I was teaching these cases, and there's a place called, I can't think of the native name for it, but the non-native name for it is Devil's Tower, and it's a feature in Wyoming, and it looks like a bear has, according to the native story, a bear has sort of scratched at the trunk of a tree. It's got striations down it. Sacred to the Lakota. They have ceremonies that they perform there in the month of June, and they asked I believe it was the Forest Service, I can't remember, BLM, who manages it as a national monument, to do a climbing ban. And one of the things Employment Division versus Smith said, we don't have to accommodate you, but legislatures and executive can accommodate your religious exercise. You don't get to get out of a neutrally applicable law, but we can facilitate your practice. And so they tried to institute a ban, and then the climbers, commercial climbers, sued to say, well, that violates the Establishment Clause. So to me, tribal practice seemed to be kind of caught between the Free Exercise Clause, which didn't quite get that protection, and the Establishment Clause if they tried to get accommodated. And so I began talking with free exercise scholars about what is this, and has this arc of Native American religious practice affected essentially a drag on the Free Exercise Clause jurisprudence? Is it overrepresented in these kinds of cases, and why do they lose every time? And so I think that is part of what has interested me in the issue, and how we think about coercion. Now, my co-author on a piece I wrote on this doesn't like when I say this, so free exercise scholars don't love this, but there's a case, and you can correct my characterization of the case, but the Little Sisters of the Poor. And my characterization of the case, which may be biased, but they essentially had to fill out a form to say, we aren't providing insurance coverage. We want to opt out of Affordable Care Act insurance coverage that would lead to that contraceptive coverage being provided. And that was found to providing the form set in motion a series of things that violated their beliefs, and that was a substantial burden. And so I think there seems to be a mismatch on when we characterize a burden, and I think Joe has correctly characterized it as carving out for special disability land-based practices, and that's what the Ninth Circuit seems to do. And with that, I'll turn to Beth.
Thank you. Hi, everyone. My name is Beth Wright. I'm a staff attorney at the Native American Rights Fund in our Boulder, Colorado office. And I'll talk a little bit about my personal background and then NARF's role in this case. I come from two Pueblo nations in New Mexico, the Pueblo of Taos and the Pueblo of Laguna. And if folks are familiar with either of those, Laguna was once home to the largest uranium mine in the world. And when the federal government and the private mining company came to the tribe to ask to put the mine there in Laguna, they said this is going to bring a ton of economic development to the tribe. This is going to bring jobs. This is going to bring opportunities to tribal members that you haven't seen before. And while some people from the tribe were supportive of that economic development, other people from the tribe questioned what that would mean the tribe would have to sacrifice. And in the end, it did bring certain economic development opportunities to the tribe, but we also lost a lot during that time period. We lost not only some of our sacred sites and our sacred burial sites, but we lost the way that the tribe functioned. All of a sudden you have, it was mostly men who were working in the mine, so you have this difference in men from the tribe who are now making a ton of money, and women from the tribe who aren't working in the mine and they're not making the money. So it changes the gender roles of the tribe, where we were primarily a matrilineal tribe, but now all of a sudden men have this economic power that they didn't have. And so that changed a lot of our just the way the tribe worked, the way that the tribe was traditionally built. And so I think that kind of bears on a lot of the sacred site cases that we see today. But also I'm from the Pueblo of Taos, and if you know much about the Pueblo of Taos, one of our most sacred sites is Blue Lake. And Blue Lake was taken by the federal government and designated as national forest land in 1906, and the tribe spent 70 years fighting for the return of Blue Lake. They litigated in front of the Indian Claims Commission. They went to Congress. They lobbied their senators. And eventually, the Nixon administration returned Blue Lake to Taos Pueblo and restored the tribes. And along with that, restored the tribes' sacred practices. And so I think that those two examples really bear on, bear on Apache Stronghold and bear on the scope of religious freedom today. We're talking about the tension between economic development, the government's property rights, and tribal religious practices. And you can't have all three. And I think we really see that in Apache Stronghold. And what's important to understand is that a lot of these cases, what's missing is the historical context of how the federal government ended up with this land. And so that was NARF's role in this case. NARF wrote an amicus brief on behalf of 52 tribal nations and tribal organizations at the petition for cert stage to talk about the historical context that led to why Oak Flat was now federal land. And it's not just the unilateral taking of tribal land to support the government's interests, but it's also understanding the context of how the federal government specifically suppressed tribal religions to build the nation that we have today. And that context is key to really personally, this context is key to really understanding what it means to substantially burden religion, is you have to understand the historical religious suppression as well when you do these types of analysis. So that was NARF's role. We talked about all of these different examples of historical tribal religious suppression as well as historical land grabs on behalf of the United States. But it's been great to work with these two and their scholarship, and I'm happy to be here and to talk more with you. Thank you.
Could I make one? Real quick point that I think Beth raises. These are ultimately questions about our values. I use the example of Mauna Kea in Hawaii, which is the most sacred site for Native Hawaiians. It is owned by the state of Hawaii. It is leased to the University of Hawaii, and it happens to be one of the greatest places on earth to build a telescope. And so we have this conflict of values. Scientific inquiry is important. Property rights are important. And religious exercise and economic development, those are all important. And so I think these kinds of cases provide us an opportunity as attorneys, and you'll go out and be legislators and judges and all those kinds of things. But how does law reflect or entrench or alter our values, and what do we value most? And where does the religious exercise of dispossessed tribes fall in our values? And it can happen, like in Blue Lake, where, for whatever reason, the Nixon administration chose the value to return, I should say, Blue Lake. So those values can prevail.
Thank you. We'll start with some moderated questions, and then we'll have opportunity for the audience to ask questions. But why should people of all faiths be concerned about protecting sacred sites for the religious exercise of Native Americans? Just adding, I guess, to some of the points that's already been made.
Sure. I'll take the first swing at that. Yeah, I mean, I would say, the most obvious response is, there's only one RFRA, only one free exercise clause. So the precedent that gets made under those laws apply to everybody. So there's sort of a self-interest aspect. But, there's also a justice aspect, right? We've seen religious liberty law has been very protective for people of all faiths in recent years, which is great, including for the Little Sisters of the Poor, which that was our case, and we'll save our disputes over that for another time. But I would say, exactly in the same way the Little Sisters of the Poor were properly protected, so should Apache Stronghold. And I think the really troubling thing about sort of the reasoning of the Ninth Circuit's opinion that will have a major impact on all religious freedom claims going forward is the way the court sort of imported the strict scrutiny side of the RFRA analysis, like the compelling interest side of it, into the burden analysis, when those are really supposed to be two separate things, and they have to be. So the court was clearly motivated by the notion of this is very valuable copper. the government has reasons that it needs to use land sometimes, and we can't let people have religious vetoes to that, et cetera. But these are sort of on their face, obviously, sort of strict scrutiny considerations about the government interest. They have nothing to do with the burden, the effect on the religious practitioner's ability to exercise his or her religion. And the good thing about strict scrutiny is, like, it exists for exactly this reason, to make these sort of balancing value judgments in the way that Michael was just laying out. So, you know, strict scrutiny forces the government to really think, is there an alternative here? Is there another way we can accomplish our goals? Is there another way to get the copper that may be needed if the government shows that copper really is needed? And, you know, it's interesting, you know, about on that point, right? This is actually, there's been a lot of talk recently about increasing domestic mining capacities and the need for that. This is a foreign-owned copper mining company that's going to get the site. And it's a copper mining company one of whose majority shareholders is the People's Republic of China, who's been competing with the United States for minerals that are important for strategic ends. So it's kind of bizarre that we've got those sort of you know, strict scrutiny type considerations playing into the burden analysis when the government has never proven its case on strict scrutiny. That remains to be done. Right? We're just talking about burden now. And when that strict scrutiny showing on its face seems quite questionable. You know, that's something that would be litigated more thoroughly later.
I might get some pushback on this answer as well, but I think that the court does have an appetite for expanding religious freedom, but I think that's often for Christian-based religions. I don't think you get the same outcome in a case like Hobby Lobby if the people aren't, if the owners of Hobby Lobby aren't Christian. And I say that because I think that there might be a different answer based on if it's a majority religion or a minority religion. And I think, you know, for those folks who are members of minority religions, having a consistent definition of what is substantial burden is crucial. But I think those folks that are from more dominant majority religions have a specific accountability to tribal religious freedom, especially in this case. I think if you look at the history of the United States treatment of tribal religions, it was mostly the Catholic Church, Christian denominations who were actively suppressing tribal religion. And so I think if you're a person of faith from that type of religious group, there is some sort of responsibility there to now protect tribal religion that your majority religion once tried to suppress. And I think that if you really understand the history of how children were forcibly removed from their families and sent to boarding schools across the country and what the boarding school era did to tribal nations, then I think you understand that responsibility a little bit more.
Yeah, and I'll just say, I think that last point was very eloquently put. I'd also say, you know, this court has been willing to stand up for minority religious practitioners in several recent cases. So the Holt versus Hobbs case was a case about a Muslim prisoner that needed to grow a beard in accordance with his faith. Justice Alito wrote a terrific unanimous opinion protecting his religious exercise, and that was one of our cases. They've stepped up for minority religions on death row, people that have religious needs that need to be met in the execution chamber, and there have been cases going both ways in that area, but some where they've protected the religious exercise. So I think that they've been willing to do it, and in this case, but this case really it does ask the question, you know, on this sort of grand scale, right? This existential burden to Native American religious practitioners. Like, is the court going to be there to step in and apply those precedents? And I hope the answer is yes, but that's what remains to be seen. Oh, sorry.
Do you want to? No. You sure? Okay. As Mr. Davis has pointed out earlier, for many tribes, religious exercise is place-based. For example, we conduct ceremonies in specific areas during specific times of the year. These areas are considered sacred grounds, as told in our creation stories. How does the current interpretation of the Free Exercise Clause and the Religious Freedom Restoration Act create hurdles for place-based religions? like Native American religions? And is there anything driving the rulings against Native American religious practitioners in sacred site cases?
I don't know what's driving it other than a little bit of a square peg, round hole problem and the values problem, right? That the way the questions are being framed, it pits as a zero sum property rights and the government's right to use its own property and the religious exercise, and property rights prevail. I think that's part of it, have prevailed. Even when Congress comes back and tries to do something, then we're still, and by the way, I was rooting for the Little Sisters of the Poor. I do agree that they are burdened. I just think also the tribes are burdened, and I don't totally understand the mismatch of the outcomes there. But I live in Utah. I was down in southern Utah in going to hike in Zion's National Park, and you ride a little tram up to your trailhead, and they were playing a little, audio as you ride through this beautiful scenery, and they were saying, this cliff is very popular with climbers, except in the months of April and May or something like that, when we have a climbing ban, so the California condor can nest. And I remember thinking back to the Devil's Tower case and thinking, I'm, again, 100% for the California condor. May they nest, may their little condorlets be plentiful, and may their nests be full of little eggs that successfully hatch. But it did seem strange to me that there is a lesser protection for the religious exercise when religious exercise is enshrined as one of our top values in the Constitution. And so how have Native religions fallen through the cracks? I think that's my answer to your question, is that it seems to be maybe quasi-religious in some ways to some courts thinking about it, or they may not see how the category, like, you can believe it's still sacred. We're not compelling you not to believe that it's sacred. And we might diminish the quality of your experience, but that's just not what the Free Exercise Clause does, the cases have said. And so I think it requires a rethinking, and I think this case offers a great opportunity for the court to rethink why Native religious exercise, indigenous practice, falls through the cracks of that protection.
I agree with that. I also think that, there's a line from Ling that the majority in Apache Stronghold relies on, which is the federal government can do what it wants with its land. And I think that's kind of the linchpin that really hurts us in this scenario, because if you, like I've been saying, if you understand the historical context of how the federal government acquired land, it's not the federal government's land. Tribes bargained to maintain their land bases in treaties, and consistently, over and over again, the federal government broke their promises in treaties. And so, that line is in Ling. There's no citation to it. I think it's maybe derived from Bowen v. Roy, but I think that it's that's what's really hurting us, is that the historical context isn't there. We're not understanding that that, especially in the Oak Flat context, the Apache signed a treaty with the federal government, and the federal government was supposed to set the boundaries of the Apache's reservation, and within that was supposed to be Oak Flat, but the federal government never defined the boundaries of the reservation. And so, tribes lost control over their sacred places through a lot of really devious acts by the federal government. And I think that that line in Ling fails to understand the federal government's trust relationship to tribal nations as well. These aren't just individual citizens that the federal government is dealing with. These are sovereign nations that the federal government is dealing with. And so I think there's a different standard that the federal government should be applying when they're dealing with tribal religious freedom of a sovereign nation.
Yeah, and I'm glad Beth raised that line, because I think the other thing about that line is it's just blatantly untrue, right? I mean, even if you assume it's the federal government's land, the federal government can't do what it wants with its own land. There's tons of environmental laws that the whole point of which is to restrain what the federal government does with its own land, right? The California condors get to have their nesting season, as Micklin pointed out. That's on federal land. So it's kind of a perversely unrealistic point of view, in addition to one that has significant historical problems in the way that Beth just laid out.
Thank you, Beth, because that was the next question. So again, to give our audience context, the Supreme Court decided Ling versus Northwest Indian Cemetery Protective Association before Congress enacted the Religious Freedom Restoration Act. And that's what the Apache Stronghold's claims are going under, is the Religious Freedom Restoration Act. And the Religious Land Use and Institutionalized Persons Act. Then the Ninth Circuit recently determined that the RFRA, which is the Religious Freedom Restoration Act, absorbed the Ling decision. What are the flaws of this interpretation, and how does the Ling decision affect Native American religious exercise claims?
Touch on this one first. Yeah, so I think the kind of the backdrop that Micklin gave earlier about Bowen and Ling and Smith is really helpful here. So Employment Division versus Smith is a free exercise clause case. It's before RFRA was enacted. And what it says is effectively, if what the government has done is neutral and generally applicable, like if it wasn't just trying to stop a particular religious practice, it was just passing a rule or a law that applies to everybody, then the fact that that law also impacts your religious practice doesn't get you an exception. And Ling came a couple of years after, or excuse me, Smith came a couple of years after Ling, but it relied heavily on Ling. So the seeds of the Smith decision were sort of already there in Ling, because what the court said in Ling was, this is just an incidental burden on the Native Americans' religious practices. Like, this law was not about crushing the Native Americans. It was about just building a road so we could have more lumber. And you don't get an opt out to that. You don't get to stop that just because that action has an incidental burden on your religious practices. The problem with importing Ling into RFRA is that the whole point of RFRA was to reject that rule. So RFRA is a statute that Congress passed 3 years after Employment Division versus Smith. And its core purpose, stated right there on the face of the statute, is to say that even if a burden is just incidental, even if it is imposed under a neutral and generally applicable law, then even so, that's still a burden, and the government should have to think really hard about giving an exception. It should have to go through this compelling interest, least restrictive means analysis. So kind of like the classic example of like how to think about Smith and RFRA is imagine prohibition, right? A ban on no wine, period. Should be consumed in this country. Can you get an exception for communion, right? That's a neutral and generally applicable law. Nobody can have wine, but it still is quite a burden on religious practices that use wine as part of their sacraments, or peyote, which is of course what Smith was about. And so RFRA would say, yes, you can get an exception. Smith would say, no, you can get an exception. So in the Apache Stronghold case, it's sort of a perverse move to bring in Ling and say Ling applies under RFRA and forecloses this claim, because the entire point of RFRA was to move away from the sort of analysis that was applied in Ling. Ling it's not mentioned in the text of the statute. The text of the statute has its own language, substantial burden, compelling interest, least restrictive means. And the way that we interpret statutes typically is by trying to understand what the words mean, not by sort of looking back to old Supreme Court cases and finding them to be like the secret key to a statute that was passed years later and that does not mention them at all. So, I think what the court could say is that this is just this is a RFRA case, and Ling doesn't apply under RFRA. I think Ling's also a little different, and I'm curious what the other panelists think here. But I mean, Ling, it was also about construction at a sacred site, but it was about a road that was going to sort of go through an area that was viewed as sacred by many of the tribes in the area. They could still access the site. Micklin was talking about sort of access and desecration, right? And so, their claim was really more like, this is a sacred site. It desecrates it to have logging trucks go down the road. It makes it noisier and harder to engage in our religious practices there. And that could all very well be true, and that they very well should have won their case. But that still seems quite different from Apache, because what's happening in Apache is the site it's not going to be there. There will not be a site. It will be swallowed in a massive crater. the Apaches won't have the ability to go there and exercise their religion, whether it's been desecrated or not. They just won't be able to go there. So, that's sort of the distinguished Ling path, but there's also just the Ling doesn't apply under RFRA path.
Yes, so that is the question, is what did RFRA do? Obviously, Congress can't go back and tell the Supreme Court how to interpret the First Amendment. That's not for Congress to do. It's emphatically the province and duty of the court to say what the law is, and they will interpret the Constitution. But Congress attempted something with RFRA, the Religious Freedom Restoration Act, which ultimately applies to the federal government, where the federal government said, we'll constrain our use of land and we'll constrain our laws with this new statutory mechanism, right? The analysis of substantial burden. And I think what the Ninth Circuit, the implication of their rejection of the RFRA claim here is basically saying that Congress didn't do anything. They just wrote a statute that replicates the free exercise clause, and that's sort of nonsensical. Obviously, RFRA was trying to do something that was, they couldn't go back and change the way the court had interpreted the First Amendment, but they could impose sort of a new set of standards that maybe use some of the same language, but seem to be trying to get at something. And they specifically say in RFRA that they mean to go back to precedents before Smith, but they're silent on Ling. And so that is, I think, an inviting opportunity for the Supreme Court to be able to clarify what's the relationship between free exercise jurisprudence and the RFRA standards, and what was Congress doing to bind the federal government's use of those use of the lands. And right now, it seems like the Ninth Circuit is saying, well, there seems to be this carve-out from RFRA standard that only applies to Native American land-based religion. And that seems untenable.
So then 10th Circuit Judge Neil Gorsuch took a different approach in Yellow Bear v. Lampert. And in Yellow v. Lampert, it was a case about a Native American prisoner who was trying to attend a sweat lodge ceremony, and he was prohibited by the prison to do that. And Neil Gorsuch took a different approach to what substantial burden meant. Why is this case important for Apache Stronghold's claims regarding the interpretation of the Religious Freedom Restoration Act? And are there other examples of cases that have stood out that Apache Stronghold has used?
Yeah, so I think the Yellow Bear decision is really important. So this is a decision from the 10th Circuit, but it really it creates a split with how the 9th Circuit approached the substantial burden question in the Apache Stronghold case. And what then Judge Gorsuch said, the question was it a substantial burden for this for Yellow Bear, a prisoner, for the prison to decline to allow him to access a sweat lodge that was at his prison? Like, he was a maximum security prisoner and they didn't want to take him there. And he said that he had a claim under the Religious Land Use and Institutionalized Persons Act, which is a sister statute to RFRA, but it has the same language. And what Judge Gorsuch said was, so, it's a substantial burden even to make religious exercise, a little bit harder, a little more expensive, right, to fine people for engaging in religious exercise. If that's true, and it is under the court's precedent, then of course it's a religious exercise a substantial burden to entirely prevent the person from engaging in the religious exercise. And that's what's happening here. If the prison doesn't take Mr. Yellow Bear to the sweat lodge, he can't exercise his religion at the sweat lodge, and that's an obvious substantial burden, was how then Judge Gorsuch reasoned. And you apply that to the Apache case, and I think you get a pretty clear answer, right? Not only has the government made it harder for Apaches to exercise their religion at Oak Flat, it's going to make it impossible, because it's just going to destroy Oak Flat and swallow it in a massive crater. And I think what the Yellow Bear case really kind of points up is, so the way the Ninth Circuit distinguished Yellow Bear was it said, well, that's a case about prison, and in prison, Prison's different. Prisoners are sort of forced to be in prison, they're coerced to be there, and so of course the government has kind of an affirmative duty to facilitate their religious practices. But in a great law review article that Micklin wrote in the Harvard Law Review, that distinction doesn't really work, because actually land use claims involving federal land are analogous to prisoners in prisons, right? In the same way that prisoners can only exercise their religion if the government facilitates it. It's federal land, it's a prison, or it's government land, it's a prison, and the government has to facilitate exercise there if it's going to take place. The same is true in federal land. If the federal government takes ownership of land and says, we get to call the shots here, then they have an affirmative duty to accommodate the religious exercise that had been occurring there before and continue to occur there. So it's sort of perverse that, under the Ninth Circuit's Apache decision, the condors are more protected than Native American religious practitioners. So are prisoners who have presumably done something that has allowed their civil liberties to be a little more reduced than the rest of us, and yet they're protected in sort of the yellow bear scenario.
Yeah, thank you for mentioning my Harvard Law Review article. I am legally required to mention it in every public appearance, so at least that's what I tell myself. So one of the arguments that we make in that article is that there is in sacred site access a baseline where the federal government has possession. It is like other situations where there is a baseline of coercion, where there's a special duty to accommodate access, like if you're in prison or like if you're in the military, and the federal government has to make certain accommodations to allow, they have exercise a kind of pervasive control over you. And as Beth talked about, the way that the government has become the fee owner of a lot of the land was at the cost of the tribes and breaking treaties or other kind of confiscation. And it seems to me to tell a broader story about that has been told many times, that has replayed itself many times. We may need the copper, or the Chinese mining company may need the copper. I don't mean to be facetious, but I use an iPhone. I'm sure there's copper in there, et cetera. But how do we allocate the benefits and the burdens of what we're trying to do as a nation? And many times we have placed the burden on the tribes and then without the attendant benefits on tribes. And so this seems to me a very good example of heaping the primary burden while we hope the nation reaps the benefit. It's the same thing with the siting of pipelines, where that may be, necessary to our energy economy, without arguing that point. Who's bearing the burdens of the risks for the siting of that pipeline, and why is it that it is always easier to heap up those burdens on indigenous people or minority people or other, like environmental justice concerns, but not just in environment, in other contexts, and when the benefits are spread more broadly or even concentrated outside of the community?
I agree with the other panelists, and I think what yellow bear symbolizes is that there should be a more context-specific inquiry into what a substantial burden is, and that should be a part of the court's analysis when they're going through how the government has historically substantially burdened a specific exercise of religion. So I think, Professor Steele's law review article, it talks about just how the government has maintained control over access to these sacred places.
And the federal government also owes a trust responsibility to the tribes, which is sort of tacked on at the end of my article as sort of, and also what you're trying to do, you can do differently when you're dealing with tribes, because you do have the additional power and duty of the trust responsibility.
How do you expect the Supreme Court to rule in the Apache Stronghold case if cert is granted? Or, yeah.
That's the only scenario that
Yeah, because they haven't granted.
That's right. Well, yeah, we expect them to grant cert, and we expect them to rule for the Apaches. Maybe I expect that every time I put a cert petition up there, but no, I think this one is it's the kind of case that typically captures their attention. You have a very splintered Court of Appeals. You have what looks a lot like a split among the circuits in how to interpret this language, substantial burden. It's of great importance, right? They only take a handful of cases every year, so it needs to be important. And this is quite important. We have a sacred site, particular religious practices that will be extinguished forever unless the court intervenes or unless there's another way of stopping this land transfer and copper mine from being built. And I think what's really fascinating is, and the last factor I'll say is that there was a massive sort of amicus push at the cert stage from people of all faiths saying why the court needed to step in, and from a massive group of tribes. And these are the kind of things that can drive up the likelihood of a grant of certiorari quite a bit. But another kind of consideration that the court often looks at is this decision that we may or may not agree with, is it doing harm? Is it sort of expanding and doing other things in other cases, or is it kind of a one-off? And I think one thing that's really fascinating about the Apache case is, as if to make as clear as possible that this was a big problem for all religious practitioners, immediately after the Apache case came down, the federal government turned around and they cited it to say to the Knights of Columbus, it's a Catholic group, they had sort of an annual Veterans Day Mass, maybe it's Memorial Day Mass, at a veteran cemetery in Virginia. They'd had it for years and years, and they have a Mass, and it's on federal land. Apache Stronghold case comes down, the federal government says, Masses can't, no more Mass, no more Memorial Day Mass, it's our land, and Apache Stronghold says that you can do this. So it's almost like putting a fine point on how big of a problem this case is, how it's not likely to be a one-off, even if, the one-off is quite bad in and of itself and cert-worthy in and of itself. So, the court it's been pending on certiorari for quite a while now. That means, they consider it at their Friday conferences during the term. They've done that, I think, 9 times. They've relisted it quite a number of times, which suggests that they're thinking quite hard about it. A decision should be coming, any day now as to whether they'll grant cert or not. This issue is not going away regardless, though. So, stay tuned.
I also think it's just important to note that even, if the court takes this case and rules in favor of Apache Stronghold, it's likely just to say that there is a substantial burden here, or that Apache Stronghold has an opportunity to get to the substantial burden question. And so then I think what's important to remember is that it's still scary that the government there's still the strict scrutiny analysis there. And so, I think, one thing that NARF is obviously thinking about is like, what does that strict scrutiny analysis mean for tribal religious practices going forward as well? Is it always going to be the federal government? Okay, there's a substantial burden, but we're always going to win on strict scrutiny, because we can always say that we need this copper for national security, or we need this uranium for the move to the green revolution. So I think we're still in a space where we still have to worry about protecting tribal religious practices, even if we win this case, which I hope we do.
I would love to be optimistic, and we'll see. I think it's important to remember what happened after Ling, so that logging road never got built. But it was not because the courts delivered or the Constitution delivered. It was because the people delivered, and they got the area designated a wilderness, which by definition is no roads. And so the tribes have frequently turned to the political process when the courts have failed them, and there is always that option. The political process sort of put them in this bind, but there is still that. They're never fully defeated until you're fully defeated, I guess. And so, but I find it interesting that the courts may fail. I don't know. I would hope that the Constitution and RFRA mean something more than they have meant, and there may be a political process as well. But I find that these kinds of claims, as they get presented, frequently have to, the nature of native claims, I think it would be important to say, frequently have to sort of partner up with something else, like a land use or an environmental interest, or it's historically important, and they haven't been able to really succeed on their own merits, but they have succeeded if they can find some other archaeological resource or a historical protection, or they seek some kind of, let's name it a national historic register or something like that. So tribes are very creative about trying to use all the tools at their disposal. But at its base, this is a religious exercise that ought to be afforded the dignity of the religious protections that are enshrined in the Constitution.
Looking forward, what emerging threats to sacred sites do you foresee, and how can federal laws evolve to address these threats while upholding religious freedom for Native Americans and tribes?
I'll briefly say that the Apache case, I mean, it's the en banc Ninth Circuit, right? So it's the law of the whole Ninth Circuit now, and the Ninth Circuit is the circuit where the most tribes are located, where presumably the most sacred sites are therefore located. And what the Ninth Circuit has just said is those sites can be destroyed with impunity for any reason or no reason at all if they're located on federal land, and religious freedom law just has nothing to say about that. Maybe there are other laws that would, but religious freedom law has nothing to say about it. And that's very troubling, and it's a big circuit, and there's a lot of bad consequences that could come from an opinion like that. So yeah, that's kind of the most narrow response, but I think it's one worth saying.
Yeah, and I do think, as my colleagues on the panel have said, even if we could get into the strict scrutiny analysis, strict scrutiny is a very high burden. The government it may win that analysis, even if it's a high burden. And so I think Joe makes a really good point that this may be fundamentally different from Ling in that it is an access case, and it may leave desecration cases like the Navajo Nation, where they were essentially making snow out of repurposed sewage water and, on sites that were sacred to the Navajo, and that did not constitute a substantial burden. So I think the desecration is probably one area where we'll see ongoing threats.
One thing that scares me that I mentioned earlier was just the tension between economic development, the government's property rights, and tribal religious practices. I think with those three, what I think we're going to unfortunately see more of is tribes being pit against each other because of those three things. One of the case that comes to mind immediately is the Navajo Nation just brought a lawsuit against the United States challenging Secretary Holland's withdrawal of protect a 10-mile buffer around Chaco Canyon from oil and gas drilling and future mining activities. And Chaco Canyon is one of the most sacred places to Pueblo nations, as well as the Navajo Nation and other tribes in the Southwest. And the Navajo Nation brought that lawsuit because there are individual Navajo Nation Aladi members who have interest in continuing to access oil and gas and minerals in that area. And my tribe, the Pueblo of Laguna, intervened against the Navajo Nation because they want to protect Chaco Canyon and they want to maintain Secretary Holland's withdrawal. So I think that my law firm, the Native American Rights Fund, we don't take cases that are Indian v. Indian. We don't want to get involved in those kind of disputes. And so, I think, we're going to have to make some tough decisions over the next couple of years. Are we, protecting the tribe's right to economic development, or are we protecting the tribe's sacred sites? And I think that's something that's scary to me. That's on the horizon. Is, as a tribal member myself, am I, do I? Is it tribal sovereignty or and economic development, or is it sacred site protection? Like, can you have both? And I don't know.
Thank you. We have time for audience questions. Does anyone have a question?
Sorry. Was that?
Oh, no, I need to leave.
Oh, okay, sorry. So I have a two-part question, actually. I have to admit I don't pay attention to the other circuits like I do the Ninth Circuit, but I was wondering, is it hopeful that the Ninth Circuit seems to get it wrong so often going forward? And the second part, really my real question is there a political backup plan? Is there like a state level or federal level plan to maybe try to make that Arizona property wilderness, or is there any kind of political backup plan?
Yeah, so I'd say, let's see what happens at the Supreme Court, and that's probably as much as I'd want to say on the second piece of that question. On the first, I think you're onto something. No, the Ninth Circuit is, I think it is quite important that that's where it comes from, not necessarily for the reason that you gave, but more for the reason of, this is where a lot of these disputes are going to arise, right? So even if you can't really sit back if you're the court and say, I want this issue to kind of percolate some more. I want some other circuits to weigh in on it before we get involved, which is what they like to do sometimes. They like to have lots of cases from different circuits addressing exactly the same issue and responding to each other, et cetera, before the court kind of takes it and gives a national answer. But here, that sort of percolation is not really realistic. Like the Ninth Circuit's where most of the action is in this area. And now you've got, and now you've got this opinion sort of clearly saying there's this carve out for religious freedom cases. So, I think the origin of the case does matter quite a bit here.
I would love to know what the backup plan is, but I will also mention that when Apache Stronghold was petitioning for cert, they went on a tour across the United States to different tribal nations, building that support. I think obviously what unites tribes is that most tribes have sacred places, so that this case impacts everybody. And it was really amazing to be a part of that journey. Apache Stronghold, I think they started in Washington and then went all the way across the United States to different tribal nations and ended up Washington State and then ended up in Washington, D.C. And so I think that type of tribal advocacy is essential here, and it has to continue no matter what happens. And I think from cases like Ling, like the return of Blue Lake, we see that tribal advocacy itself is really effective and is really crucial. So I think it's important to keep leveraging that and keep building that, because in the end, that might be all we have.
Yeah, I would just build on that to say, tribes are very sophisticated. Many tribes are very sophisticated in their lobbying efforts and legislative advocacy, and they need well-informed and skilled lawyers and lobbyists in that. And I think tribes have access to a lot of really great litigators and hopefully the lobbying capacity, which has been growing in reach and influence. I think this deal got sort of stuck into a bill that was otherwise, it wasn't like a big considered decision by Congress. So it's easier to stop something than to enact something, but I don't think there was much opportunity, and it may have been stopped. The tribes may have been able to stop it if they'd have known it was getting slid in the middle of the night, kind of a thing.
And I'm glad you raised the factual backdrop, because maybe it is worth saying like exactly what the political action was that led to this conflict in the first place. It is an act of Congress. It's a statute that was sort of slipped into a defense bill at the last minute, right before government shut down in 2014, right? So nobody discussed this. Is this a good idea? Nobody, there wasn't like floor debate about it or anything like that. But it ended up in a statute. And so the only way to make it go away, the statute says the land has to be transferred, right? So RFRA it's a superior source of law. RFRA sort of applies to all other federal statutes. So that's why we have the RFRA claim, and of course the Constitution does too. But that, it puts a limit on what the political answers are, and I think the ball is in a big way in the court. So.
Do we have any more questions?
You spoke about how these RFRA issues or your protected spaces end up falling between where it's coercion and the establishment. I'm just wondering when you're briefing or like as you're arguing, if there's any strategy that you take in order to avoid one of the pitfalls of one or the other.
Yeah, I'll say I think it's absolutely right what Professor Steele pointed out, that a lot of times these are the things that are invoked on the other side, like not just, we don't want to accommodate you, but we can't accommodate you because the Establishment Clause. I think that's just dead wrong. I think it's not what the establishment, it's been well established for quite a bit at the U.S. Supreme Court that accommodating religion is not the same thing as establishing religion, lifting a burden on religious exercise. The government is free to do that. So I think it's kind of an old-fashioned view of the Establishment Clause, one that the Supreme Court has been moving away from quite significantly in recent years and cases. So it's certainly one that continues to linger in the minds of government officials everywhere from coast to coast, and that's you do see those concerns raised. But the Ninth Circuit didn't put a lot of emphasis on that kind of idea. Maybe one of the concurring judges did a bit. So it's certainly in the background there and something to be thought about.
In the back.
You brought up laying in this area that the tribe wanted protected for its religious purpose. They got a workaround, designated it as wilderness instead. Similar for Blue Lake, workaround, wilderness instead. In the last two sessions, it hasn't been reintroduced this session, but Senator Heinrich and the late Rahul Gravalia introduced a bill called the Tribal Cultural Areas Protection Act. And to the extent that any of you are familiar with that bill, I'd just be curious to hear what your thoughts are about this idea of creating a tool so that tribes don't have to do that workaround. Basically, the bill would allows for the creation and the designation of a tribal cultural area, similar to wilderness. And then, in land management plans, Forest Service could recommend a tribal cultural area. And then it also has provisions for lack of a better term, co-management. As an additional tool in the toolbox, I'm just curious what your thoughts are. I mean, who knows if anything like that would pass anytime soon in the Congress that we have, but as a hypothetical tool.
Yeah, I'm not familiar with the specific bill, and I'm a sort of whatever tool works person, but I'm also a huge fan of the free exercise clause and that value, and so it troubles me somewhat that tribes keep having to reach to these other tools to accomplish what is essentially a religious exercise. But if that's what works, I would welcome it. And we have in Utah the Bears Ears, which seems like it would fit this kind of a thing right now. It's a national monument, which is a little bit of an ill fit and not always clear what can happen in a national monument designation, but it at least has been set up as the tribes are co-managing it.
I'm not familiar with the bill either, but there is the American Indian Religious Freedom, is it, and Restoration Act, or is it just Freedom Act? Just Freedom Act, yeah. That's long been held that it doesn't have any teeth. There's no enforceability with it. So I think, that's something that I think some folks are talking about revisiting is what does that law do and what does that mean to give some actual force to that law? Because that was acted in 1973 or something like that. So, and for that, it's the policy of the United States to protect tribal religious freedom and sacred sites, but what does that actually mean?
Yeah, and there have been executive orders saying that we should protect to the maximum extent possible or feasible or whatever their language is. There are other tools for protecting cultural resources, like, for example, the Native American Graves Protection Act and Repatriation Act, where there were tens of thousands of the bodies of ancestors in museums, a collection being scientifically studied or exhibited, and in 1990, Congress passed the act that for federally funded museums or federal museums, they should survey those, what do they call it, catalog those, if they could culturally affiliate them to return them. And here we are, my math isn't good, is that 35 years? 35 years later, and there are still certainly thousands of bodies where the scientists have dragged their feet on cultural affiliation, or they want it to a sort of a degree of scientific certainty. There's also the STOP Act, which is meant to keep objects of cultural patrimony from going for sale overseas, that kind of thing. And then if the federal government is working in an area and discovers graves, disturbed graves, there's procedures prescribed there. So there are other tools for protecting cultural resources, but it sounds like others would be, like an additional federal designation of a tribal cultural area sounds like a good idea to me.
Thanks for coming, guys. Do you think that the fact that Western religious practices are based around man-made places, if place-based at all, is a contributing factor behind why native place-based practices continually struggle in court? I mean, even for a secular government, the underlying religion and values of those in power would probably have a very clear impact to how they approach a legal framework for religious practices. And it certainly appears to be a common thread in a brief reading of the Apache opinion. And if that is the case, what workarounds or strategies have you found to combat that?
Yeah, it's a great question. I'd say we've our briefing has drawn precisely that analogy between Oak Flat as sort of the core sacred site for the Apache people and like pilgrimage sites, right? The Vatican or Jerusalem or something, right? If it was destroyed and the practices that take place there could no longer take place, I don't think any court in the country would have any trouble saying, of course, that's a substantial burden, right? So it probably does contribute to a kind of a misunderstanding or lack of sympathy that it's about natural places as opposed to a man-made, to a church or a synagogue or a mosque. And maybe that's having a hard time of sort of getting it across in the judicial mind or something like that. But I think the analogy is exactly right. I mean, this is where the practices take place in the same way that they take place inside a building. What the government would say to that, and what they have said to that, is that, well, those are privately owned. If the government destroys your private property, like you've got a burden because of your property rights or something, not because of your religious exercise, which just seems quite strange to me. It seems not related to the text of RFRA, right? RFRA is not about your property rights. It's about your ability to practice your religion. And it also ignores the way that these sites became, federal property or federally managed property. So it's very blinkered, myopic kind of response. Does that get at the question?
Yeah, definitely.
I'm just interested because the way the analysis in the Ninth Circuit is kind of, I don't know, just meshed up in a soup of something. And like some of these judges are newer to us, and I think like when you go through law school, you kind of get a taste for what somebody's doing, like Scalia's a textualist, and I'm just wondering if just to, I'm wondering if what you know from these judges, if they're going to have a problem with this kind of really conflated analysis on the face of it, I guess.
I guess I think I go back to what happened in McGirt and Justice Gorsuch, where he's a textualist and read the text of the treaty and said, we're not going to, just read the text out of existence here in McGirt. And I think there's textualist arguments for their job is to construe the statute, and I think. Part of the concern is that the way the Ninth Circuit construed the statute is contorted. And so I think I feel hopeful that at least Justice Gorsuch will seek for clarity in reading the text of the statute and its requirement that they undertake a substantial burden analysis. And I guess I feel like that, whatever tools they use to get there, I think there's good textualist arguments for construing the statute the way that would favor Apache Stronghold RFRA for a RFRA claim.
Some argue that why are we even using a First Amendment analysis at all? and that we should take it into, well, an indigenous law, what does indigenous law say about it? How does that apply? Some argue that it should be interpreted under like a treaty rights interpretation, which is protected and put it in a different class. And some say religious exercises, core to tribal self-government, so we should use like the Williams test infringement analysis. So why not use any of those other methods rather than burden ourselves by the First Amendment?
So I think in these specific facts, the treaty was abrogated. We have to always, whenever we're using sort of a treaty analysis, and I understand like what, let's overlay an indigenous approach to the problem. The problem sits at the Supreme Court, and so we have to use the tools that they'll recognize and use. And so I agree there's alternate ways to approach the problem, except right now we've got to construe the religious freedoms. If you're saying why does an Apache Stronghold bring like a treaty case, or the Apache Nation bring a treaty case, it is, I'm not familiar with the history of the treaty, but I imagine the treaty was abrogated, which then would have involved some kind of compensation, and then you'd be in a purely property law, treaty abrogation law situation, and I don't see the winning path out of that. That's just what comes to mind right off.
Yeah, I think what also comes to mind as well was the maybe decision to not make this as much of an Indian law case and make it more of a religious freedom case because of the way Indian law cases are handled at the court. I don't know if my panelists agree with that, but I think, more often than not, tribes go up to the Supreme Court and lose when it's just Indian law. And so maybe there was a conscious decision to say, hey, we have a better chance under religious freedom.
Yeah, so first off, there is a treaty claim in the case. So there's a treaty claim being pressed. It's not the central question in the cert petition. I think sort of the short answer is like it is a religious liberty case, right? These are the Apache Stronghold is not itself the tribe. It's made up of religious practitioners that want to exercise their religion at Oak Flat and do exercise their religion at Oak Flat, and their claim is that exercise is being burdened by the government's action. So, I mean, the natural home for a claim like that, is in the first instance, I would say, the Free Exercise Clause and the Religious Freedom Restoration Act. And six judges on the Ninth Circuit have held that their claim was meritorious, that they should have won and shifted the burden over into strict scrutiny territory. So, certainly there are other theories that could apply here that weren't brought. We didn't file the complaint, so I can't tell you about any decisions that were made at sort of that district court level. But and I would welcome other theories that apply to the extent they do. But yeah, there's a treaty claim in the case. But I would say if you want to protect your religious exercise, then the laws that are there to do that ought to be at your disposal.
I have kind of a follow-up question on that. Because often when tribes do assert religious freedom claims, they don't win on those claims. And so is there a thing like, should a tribe be concerned about bringing those types of claims, and like how often in Indian law cases it's applied across multiple different tribes? And so if they bring claims like that and lose, like what the impacts are on like other tribes and what your opinions are for tribes to continue bringing religious freedom claims?
Yeah, I mean, you always want to worry about creating precedent. At the same time, you've got whatever exercise it is that you need protected, and so often that analysis comes out on the side of suing and getting a case on file. I would say these sacred site cases have often gone the wrong way, as we've been discussing up here, but not always. My firm did a case about a small sacred site in Oregon where we actually lost to the trial court, lost the Ninth Circuit, sought cert. And when the cert petition hit, the United States Solicitor General all of a sudden wanted to settle the case and figure out a way that they could rehabilitate the site and make it like it was before. There have been cases about the religious use of eagle feathers, for example, RFRA cases, where, in general, under the migratory birds, the MBTA, you can't pick up eagle feathers off the ground to use them for any purpose whatsoever. Some Native American religious practitioners use them in their religious exercise. They've sued under RFRA, and they've won some of those cases. So I don't think it's it's not like all the law here is in one direction. Some of these sacred site cases are, and that's what we're hoping to get fixed here. But I don't think we should view it as sort of religious liberty is a non-starter by any stretch in this space.
I would just say that's a problem at the heart of federal Indian law as well, is that one tribe brings a case. My most hated case is Nevada versus Hicks, which it could not have been about smaller potatoes in one sense, that they damaged an ordinary ram head, instead of an endangered species head. So it was like the smallest possible tort, but went to the Supreme Court. Similarly, the Bay Mills case, where about tribal sovereign immunity, where it looked like designed, served up on a platter to get the Supreme Court to say that tribes did not have commercial sovereign immunity when a state is suing in that way. But when a tribe or a claim goes forward, it has implications for all 574 federally recognized and also other tribes seeking federal recognition. So that's just that is an oddity, and why I have written in other spaces about that the court ought to sort of defer on a lot of these kinds of where they have policy making implications to defer to Congress, which can make a better fit for the broad circumstances.
I have a question. Maybe. So I know that some religious, like freedom scholars outside of the Native American context, they advocate for a historical analog test. So like similar to like what has recently happened in the Second Amendment, like looking back at what types of religions did we consider as like protected or not, or those things like that. And so one of your points earlier, Beth, made me think of this because like historically in this country, many of our people have had to hide our religions. We've had to hide our ceremonies, and because we weren't allowed to practice those beliefs. And so why would that kind of test be even obviously I'm already kind of answering it a little bit, but like even be a bigger hurdle for tribes?
Yeah, thanks for that question. Are you talking about like the history and tradition, like whether the U.S. has a history and tradition of like doing a certain thing? Yeah. That would definitely be hard in the context of tribal religious practices, because the United States' Indian civilization policy, which lasted 200 years, was like an explicit policy to destroy tribal religion. But I think that's where the need for a historical context when you're looking at a substantial burden is important, because then you take into the context of the historical nature of the religious suppression and all of the facts around that versus the history of the United States treatment of that religion.
Yeah, I really appreciate that question as well. I mean, I think another thing that the court's recent move toward history and tradition under multiple constitutional provisions, even at the same time as it's done that, it's also said, it's not, tradition alone doesn't tell us what the Constitution means, because you could have traditions that are blatantly inconsistent with what the constitutional text says. And so there's a religious freedom case about, religious schools being excluded from public funding. And the government came back and said, no, there's a long tradition of excluding religious schools from public funding. Like in the 19th century, we didn't like it when all these Catholics were coming into the United States, and so we didn't want them to have Catholic schools, so we didn't give them any funding. And the court said, well, that's a tradition, but it's not the kind of tradition that informs our understanding of the First Amendment. That's blatantly contrary to, religious freedom for all and and respecting, religious liberty for all Americans. So, to the extent that the government were to say the relevant tradition here is crushing Native Americans' religious exercise, like that can't possibly be the kind of tradition that informs our understanding of the First Amendment. And I think to the extent we're looking for an analog, right? I mean, the analog is like one of the questioners was saying earlier, it's gathering together and exercising your faith in a sacred site, and that's what all most religious Americans do, and that's always been viewed as the heart of protected religious exercise in the First Amendment.
Thank you to our panelists. I think we're out of time. We can't have any closing remarks. Sorry, but I don't know if you had any dying things to say. But yeah, thank you. If you have any questions, you may come up here and ask some questions afterwards. But thank you for coming.